I'm David Lombardo, and this is WCNY's The Capitol Press Room. In the aftermath of Governor Kathy Hochul successfully pushing for statutory limitations on lawsuits related to car crashes as part of her campaign to address car insurance costs, business interests are hoping that additional liability changes will be on the agenda at New York's Capitol in the future. And a report released this spring from the Empire Center for Public Policy, a conservative think tank in Albany, lays out a range of options for policymakers in this vein, which they claim will lower the cost of doing business in New York and subsequently make the state more affordable. For more on these findings, which include some of the greatest hits in liability reform, we're joined by the report's author, attorney Cary Silverman, a partner with Shook, Hardy, and Bacon, a law firm well known for providing defense services in product liability and mass tort litigation cases. Thanks for making the time, Cary.
Thanks for having me on your show, Dave. I appreciate it.
Well, I want to start with an issue that was addressed, at least in part, in the adopted state budget, but only in the context of car crashes, and that has to do with what's known as comparative fault. Can you explain how this principle is generally applied in New York and what you think the standard should be moving forward?
So, comparative fault is a principle where a person who is it figures out how would we pay damages in for personal injury cases. New York's of a few states that, in most respects, has what is called pure comparative fault. So, if a person is 50% responsible for their injuries and they bring a lawsuit, they get 50% of their damages. If they are 90% responsible for their injuries, where they're actually primarily at fault for what happened in the accident, whether it's a trip and fall or a car crash, up until recently at least, even if that person was 90% responsible for their injuries, they still get 10% of their damages. Most states don't have that system. Most states have adopted what's called modified comparative fault and had that for a while. And that means if a person is primarily responsible for their own injuries, they're more than 50% responsible for their injuries, they don't collect any damages. That seems like a common sense way of approaching the situation. New York recently changed that rule just for auto cases. It hasn't changed that for anything else. And I think this is a really fundamental area of tort liability because what it means in practice is it means that very weak cases will be brought against people that are viewed as having deep pockets, especially. A person up until recently, if a person gets into a car crash, it's 90, there's no question barely that it's their fault, 99% responsible. But they could find someone, their lawyer can think of someone, that was remotely involved in that accident that they could shift the blame to. Maybe there was a truck that was slightly sticking into the intersection that someone, blew through an orange light, had an accident. Maybe that truck driver was 1% responsible. Maybe there was an accident on the Belt Parkway, and arguably the other person in the accident was going 10 miles over the speed limit, even if the other person was at fault. So those are the types of situations where in most other states, those cases just wouldn't be brought. Maybe there's just, it was an obvious issue. Someone was running through a supermarket and slipped and fell, and can blame it, on the store. Those kinds of cases wouldn't get brought in other states because there would be no question that that person was more than 50% responsible. But in New York, if you could point the finger at somebody else, those cases are going to get brought, especially if there's, they're viewed as having the assets to pay part of the claim. And what happens is that defendant or their insurer is going to settle the case because they're going to make the judgment that they're, how much money we're going to have to spend to defend against this lawsuit. What's the risk that if this does go to trial, because it's a factual issue that's created for a jury, and that's a lot of money to get through a trial, that there could still be an adverse judgment against it. So they settle these cases routinely. And so that's really the aspects of comparative fault that we're concerned about.
Well, as you pointed out, though, the decision is made that no one person in these parties is 100% responsible, meaning that there are multiple factors at play for someone being injured, for example. So even if someone might bear a slim majority of responsibility, say 51%, and someone else is 49% culpable for that negative outcome, and maybe if they hadn't been involved, the whole situation could have been avoided. Why do we want to avoid any sort of recompense for that person who is 51% involved? Clearly, I think a case could be made about 99%. That's maybe an easier argument to sell than someone 51% versus someone 49%.
Yeah, and I think there's a clarification is important when we're talking about comparative fault. We're talking about the a comparison between the plaintiff and the defendant or the defendants.
Mm-hmm.
So the issue here is whether the plaintiff, the person who was injured, you know, has the most fault for bears the primarily responsibility for what happened, whether it was their own negligence, their own carelessness that caused this. And in situations where that person is primarily at fault for what happened, we don't provide money through the tort system for that. That doesn't mean the person doesn't have health insurance. It doesn't have another way to not have to shoulder all of the burden of that. But when it comes down to their responsibility being for the accident or the injury or whatever it is, that's where comparative fault and modified comparative fault comes into play.
But why is, say, 50% the right threshold to use? Why shouldn't we have something maybe a little more lenient, like a 75% or something even higher? Why throw the baby out with the bathwater, so to speak? Why not acknowledge that sometimes it takes two to tango and maybe somebody leads and somebody follows for some of these crashes?
I think when you get over, significantly over that 50% threshold, and some states at 50%, some states at 51, but a significant majority of states have taken this approach, and that is just, I think it's there so that we don't have situations where we're bringing weak cases against defendants that bear minimal responsibility, if any, because we can always
But
allege,
some
and
could be
well,
49% and that under that threshold that you're talking about, and then they're, not responsible.
then they're not responsible. That they're not responsible.
But
That can go
without
to a
their
jury. That can
49%,
be a
something
jury.
wouldn't have happened.
That could be a jury question to figure out as to whether it's 49, and juries are going to be sympathetic, and if they're going to lean toward the plaintiffs
Mm.
in these situations, they're if anything they're going to err on the side of putting more of the responsibility on the defendant than plaintiff, just naturally.
Well, turning to a similar issue, I want to highlight the issue of personal injury attorneys trying to recoup full economic damages, such as medical expenses and lost income, from defendants who are only partially at fault for an underlying incident. This is motivated in part by the fact, which you sort of brought up earlier, that these players may have deeper pockets or greater insurance coverage than parties that were more responsible and thus wouldn't be able to make an afflicted party whole. As you note in your report, though, awards for pain and suffering can only be leveled against parties that are at least 50% responsible. What standard would you like to see moving forward for economic damages? And is this sort of the same conversation as the comparative negligence?
It's a similar conversation. This is where, when we talk about joint and several liability, we're talking about, allocating fault between, rather than between a plaintiff and defendant, but looking at the fault of if there's multiple defendants involved, what their fault is for that accident. And states have taken different approaches to when a defendant, and we're talking about whether they should have to pay the entire amount of a damage award or not. And when someone's jointly liable, what it means is if you're maybe 10% responsible for the injury, that you have to pay for 100% of the damages. New
Right.
York has sort of a unique system, where the system that's in place now is that a defendant that is even minimally responsible for plaintiff's injury, 10%, has to pay 100% of the economic damage award, their medical expenses, their lost wages, for example. But when it comes to non-economic damages, it's sort of a modified system. If they're more than half at fault, then they have to pay the whole thing. But if they're less at fault, then they pay their share of the damages. And what most states do is they don't differentiate there. A defendant that's minimally at fault doesn't have to pay more than its fair share, whatever share that is, whether it's 10% or 20% or 50%. They pay that for the entire award. They don't distinguish between economic and non-economic damages. I think other states have various thresholds for when that a defendant is jointly liable for the entire amount of damages. Most states it's 50%. There are other states where it might be 60%. I think Pennsylvania may take that approach. So I think it would be make sense to have a system in New York like most other states where a defendant that is you know minimally at fault for an accident just pays their fair share for that accident, whatever that share may be, rather than pays 100%. Because what this does, in practice, is it makes plaintiffs' lawyers will look for to sue a defendant that has based on the most cash they have, or the most insurance coverage they have, rather than the defendant that is most actually the one that's responsible for the accident or the injury, because they know that defendant, even if they're just minimally, a jury finds them minimally responsible, they're going to have to pick up, most, if not all, of the damage, and all of the economics and partial on the non-economic. So that's what happens, and so the focus is more on the money, rather than on responsibility.
And after a quick break, we'll continue our conversation with attorney Cary Silverman, who authored a report for the Empire Center for Public Policy on a host of liability reforms to be considered here in the Empire State. Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com. I'm David Lombardo, and this is WCNY's The Capitol Press Room. We're continuing our conversation with attorney Cary Silverman, who wrote a report about changing New York's liability laws for the Empire Center for Public Policy, a conservative think tank here in Albany. We'll pick up our conversation talking about potential changes to joint and several liability statutes. So what happens with someone who's injured and looking to make up medical costs or lost income and is restricted from going after a person who may not have the most culpability but has the deepest pockets or best insurance coverage and is therefore best positioned to make that plaintiff whole?
They'd sue the people who are responsible for their injuries. They would recover from the person who is primarily responsible what they can, whether that's an individual, whatever amount of insurance that person has available, if they have insurance for what occurred. And they would get their fair share from anyone else involved, whatever, based on that person or company's responsibility for what happened. Beyond that, that person would look to their own healthcare, medical insurance for coverage. In our system, what we're looking to do, it's there to compensate people for fairly and reasonably for their injuries based on
But this
fault. I
person's
think
not
that,
going to get fairly compensated if that other party that is responsible can't pay the bill.
well, if the other party is responsible, they can't pay the bill. Not from that party, they're not. But
Sure.
but what we've got is we're not going to put the burden on someone who was not responsible to pay for someone's costs that they didn't cause.
Well, does there need
That's
to be then a stronger safety net in the system for these people? Because we have a
well,
very expensive health insurance
yeah,
system. We have
yeah,
people struggling to make it. So ultimately, people are going to have to turn to medical
you
debt. They're
know,
going to have to turn to other social programs to make up lost income. So it seems like someone's going to pay for this.
we do have some programs in place. I mean, first of all, if this was a on-the-job injury, you've got workers' compensation that's going to cover something like that. If this was an auto industry, you've got no-fault insurance that's going to cover the first 50K of this. So there are things that are in place for to make sure that people have some level of coverage for these beyond health insurance.
So, when it comes to something like trying to recoup full economic damages from a defendant who's only partially at fault, is there anything that would stop a jury from simply saying, we don't think it makes sense for this partially responsible actor to pay out the full economic damages? And because they're only partially responsible, we think it only makes sense for them to pay their fair share. Is there any reason to think that they have to give out the full economic damages?
Well, the jury is going to be asked, questions about allocation of fault. Which party, how much was the plaintiff at fault? How much was defendant one at fault? How much was defendant two at fault? And how much the damages were. They're going to look at medical expenses there were. They're going to look at, what lost wages there were, et cetera. And so they're going to come out with percentages and they're going to come out with an amount of damages. And it's the court at the end of the day that's going to apply the law to those facts and say, okay, well, this party is responsible for this much and this party is responsible for that much.
Right. So ultimately, though, there's no guarantee that you're going to recoup full economic damages from that partially responsible defendant. It seems like the state allows for that possibility, but it isn't a sure thing that it's going to happen in every case.
I'm not sure I understand your question.
So my understanding is that while you could go after that deep-pocketed defendant who might be 10% responsible, and that you're trying to get the full economic payout from them for medical expenses and lost income, there's nothing that would require the court to ultimately say, yep, we agree with you. We're going to give you the full economic payout from this one party. I mean, my understanding is the statute allows for that, but you're not required as the judge and jury in a case to make the full economic payout from that partially responsible defendant.
My understanding is if the jury finds that a defendant is partially responsible under the joint and several liability law, that defendant would be responsible for the full amount of the economic damages. If I'm wrong about that, I'd have to check.
So you're saying that even though the jury might ultimately decide, yep, you're only responsible for 10%, and while you've been asking for this party to pay the full amount, you're saying the way the current statute works, they're mandated to pay out the full payout that they've been requested?
If a defendant is found partially at fault, I believe under the joint and several liability law, that defendant will be fully responsible for the plaintiff's full economic
Mm.
damages.
So why not just give the court flexibility in the system as opposed to saying, here's what the system will allow? Why not say, leave it up to the judge and jury and don't tie their hands with the full required payout, but leave that as an option?
It's an interesting idea. I mean, usually the way the law works is that the jury is viewed as the fact finder and the court applies the law to the facts. And so while there may be some areas where juries have flexibility to do things like that, this is kind of an area where we want some degree of consistency and I think predictability as to how people are going to be paid, rather than complete variation and not knowing from case to case how that's going to be treated. Just to have just fair treatment across the board, I think we kind of have to have a rule in place for how that's determined.
So, whether it's the reforms we've been talking about or changes to New York's scaffold law and its absolute liability standard, or changing to what's known as lawsuit litigation financing, I understand why, from an insurance company perspective, I would be supportive of these and how they could reduce my costs, and how, as a business, I would then hopefully be paying less for, say, insurance coverage. Ultimately, from a consumer perspective, what guarantee or reasonable assurances are there that these cost savings would trickle down to average New Yorkers?
Yeah. Well, look, I think people are sometimes right to be skeptical as to whether, tort reform, so-called tort reform laws are going to, result in a sudden drop in insurance rates or prices. I get that. And there's a lot of flat factors at play when you think about you're looking to buy auto insurance. I mean, everyone knows, especially in New York, that varies depending on where you live, what the cost of replacement parts is at that point in time, things like car safety, all of that kind of plays into an insurance rate. But one thing that does play in too is the laws that the state has in place, the liability laws. And I think on issues as fundamental as something like comparative fault or the change to what constitutes a serious injury under New York law, which makes a difference between whether cases go to, say, no fault, the no fault system, versus go to trial for a full damage award and expensive and lengthy, lawyers involved, can make a significant difference. I mean, we're seeing in Florida, for example, which was one of the few states out there that also had a pure comparative fault system like New York, made the change, among others, as New York has done too. And they're seeing significant reduction. So that's a positive. But I do caution about thinking that there's going to be an immediate sudden change in things like insurance rates, because insurers want to see, I think, I'm not an insurance expert, but insurers want to understand what the actual impact is rather than the theoretical when a law is changed. We do see in any kind of tort reform law when it's passed, the plaintiff's bar will often challenge it, the constitutionality in court, try to find ways around it. So we have to see that it's actually working and is solid in place before rates will likely change. But we also know, look, when you get in a car accident or something like that, and it was your fault, you expect your rates to go up. And I think the same is true for, when we have, a fake slip and falls outside of apartment buildings, when we have staged accidents, when we have higher damage awards, when there are lawsuits against the rideshare companies, real or imagined, those all, I think, are going to be reflected in higher insurance rates for those businesses, for those property owners, for those stores. And when they're paying higher costs, they pass on the higher costs to consumers.
Well, I want to pivot to another issue, and that has to do with advertising by lawyers. And the state court is updating the rules related to when a lawyer can advertise in relation to a specific incident. And when I think about the advertising landscape right now, I don't know what it's like where you are, but lawyer advertising is pretty ubiquitous. It's all over the place, whether it's TV or billboards. So, when we think about relaxing this more targeted advertising restrictions, do you think that's going to have a meaningful impact on lawsuits moving forward or the legal landscape at all? Or because advertising is so all over the place, and I think we all probably know some plaintiff attorney jingles by heart, uh, is there a reason to think this will be that big of a difference?
It's certainly the wrong direction. And you're right to that the lawsuit ads are simply out of control. And look, lawyers have a First Amendment right to advertise just like any other business. The problem comes, I think, when you have ads that are engaging in deceptive types of misleading ads, misleading practices that are, when people are duped into calling that number, when they're duped into calling that number on the billboard, on, the jingle on the radio, or they get one of these social media ads on their feed, and they respond to it with false expectations. They may be misled about who they're calling to begin with, what they're signing up for. They may not realize they're even signing up for a lawsuit or
What
about
are those
company.
advertisements like? This is kind of a new angle that I haven't really considered. What are the sort of misleading advertisements like? I know
Sure.
there's the concerns
Yeah.
about past results and needing to have
Yeah,
that
that's one of them.
warranty that shouldn't predict future results,
Sure.
although people should probably expect that already. But what are the concerns that you have with some of the advertising?
Oh yeah, well, absolutely. I mean, I've seen ads that are lawyer ads that are labeled as medical alerts,
Mm.
as consumer alerts, put out there in late night TV as infomercials, people presented as doctors who aren't doctors, social media ads with even with AI pretending to be victims, telling people to call and join a list you're not actually going to have to sue, things out there, websites called class action, this and that, when they're not looking for class actions at all, when they're looking for product liability, individual lawsuits, giving people the expectation that there's a settlement already there, that there's a fund they could get money from, that they don't have to sue, even saying these things in the ads that are just not true, just to get the people to pick up the phone. Because today, certain types of lawsuits are all about quantity over quality, trying to get as many plaintiffs as possible to join. And the real, winners in these cases are the attorneys, the litigation funders, rather than the people who are calling, unfortunately.
And do you think the changes to New York's advertising laws for attorneys will open the door for more misleading advertisements or allow them to happen at all?
Well, first, I think the changes are the wrong direction for really two reasons. First, what they basically did is they stripped out all of the very specific provisions about what lawyers can and can't do in their advertising and replaced it with a general, you can't have misleading advertising practices provision. And the problem with that is that lawyers are rule followers. If it's black and white and it says you can and can't do it, they will or won't do it. If you put in something that's vague, they'll take advantage of the full flexibility of that. And when it comes to enforcement of lawyer advertising, it's self-regulation by the profession. It is largely led by clients who have complaints. Usually they're complaints about, oh, the lawyer never calls me back. Otherwise, probably the second most frequent complaints is that they charge me too much. Right. So when you get to that point in a lawsuit, that's like years down the road from when the advertisement came up that made that person initially, pick up the phone. You're not going to have a whole lot of enforcement that way to begin with, but you're certainly not going to have enforcement when the only thing that's in place is something about, vaguely not having misleading practices or statements in your ads. Better to have more detail than less. And so it seemed, I heard your interview with the State Bar Association president, and she said, like, look, those detailed requirements that we had, they've gotten out of date. And so we're going to streamline them and make them more efficient by just getting, well, she didn't say this, but by just getting rid of them. And I think that was the wrong way. I think what we ought to have done, and what a couple of other states have done, either through the judiciary or through enacting legislation, is to deal with the types of practices, the changing advertising that we're seeing today, whether that's through social media or whether that's through lead generators, these entities that aren't even lawyers that are getting the ads. And the state bar doesn't have the ability to regulate people beyond lawyers, but they could at least say that, look, if you're an attorney and you're going to rely on a lead generator to be going out there and putting out ads and gathering clients, then you're going to be responsible for what advertising they're doing.
Well, unfortunately, that's all the time we have for this conversation. We've been speaking with Cary Silverman. He is a practicing attorney and a partner with Shook, Hardy, and Bacon, and author of a new report on liability reform in New York, which we'll link to in the episode page and on our website, capitalpressroom.org. Cary, thank you so much for making the time. I really appreciate it.
Thank you for having me, Dave.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.